background about my case because I've been fairly vague up until now. In 1975, the state of Washington created a law that said that no person was supposed to aid or encourage any person in any circumstance to commit suicide. This was set apart primarily for people high school aged because they didn't want people to be encouraged to commit suicide because there's a lot of extra police costs and things like that that go into investigating a suicide. However, Dr. Harold Glucksberg in 1976 got together with 3 other physicians, 3 terminally ill patients, and a nonprofit organization that counsels you in end-of-life circumstances, and said that this probably wasn't fair. There are a lot of people in end-of-life circumstances where they know that they're going to be dying within the next 6 months to a year, and they don't want to simply be put on a machine, and they don't want to continue to put their families through that heartache. So Dr. Glucksberg charged the state of Washington with violating the Due Process Clause of the 14th Amendment. The Due Process Clause was that you have certain rights that haven't been clearly outlined within the Constitution, but U.S. citizens still have the rights to those. They claim that the right to die was just as important as the right to live. However, the state of Washington said that you should not be allowed this right because they were afraid that once physicians were able to encourage these citizens to actually commit suicide or pull themselves off the machines, physicians would choose that option over talking to patients about options that they could try to stay alive with. They were afraid that hospitals that were put under financial strain might counsel more people to commit suicide or to be put off the machine just so that they could save themselves some money. The Supreme Court primarily looked into that issue and said that that was the reason why this law was under the due process, and it was a 9-0 decision in favor of the state of Washington. The problem with this case comes as a result of a 2008 decision when the state of Washington actually reversed this Supreme Court case effectually when they said that people should be given the right to choose death if they are in a conscious state and can make that decision for themselves. So the problem that we see with this case is clearly the Supreme Court interjected too quickly on an issue that they didn't have a lot of opinions on. And the importance of this case, and this case sets the precedent for things like gay marriage, abortion, and healthcare. And one of the reasons that you haven't seen a lot of Supreme Court cases about these issues yet is because the Supreme Court is taking a step back and waiting for multiple states to weigh in. This is the best way that we ensure democracy in the Supreme Court, which is the 3rd branch, is because now they can view the opinions of the United States. One problem that we had back in 1997 when this case was officially decided was we saw the problem that a lot of people were turning back to 18th century United States ideals and weren't looking at what were the problems going on right now. And so the way that you should be voting in this debate is vote on whatever has had the lasting effects and vote on what is relevant. First, I'm going to talk about Gibbons v. Ogden. My case proves that Gibbons v. Ogden didn't have a lasting effect. If the federal government making a decision really was the end-all be-all, we wouldn't have had a Supreme Court decision overturned by one of the own parties and the party that was ruled in favor of in a Supreme Court case. So the fact that you have cases like my case proves that Gibbons v. Ogden didn't actually establish federal superiority over the states. That's one reason why it hasn't had a lasting effect. Also, we don't want these type of cases to have a lasting effect. If his case and the federal decision was the end-all be-all, we wouldn't have seen the overturning of things like Plessy v. Ferguson, which ruled that separate but equal was absolutely okay. After Plessy v. Ferguson, several states changed their ideas, and then finally this was re-presented to the Supreme Court, and they made the Brown v. Board decision that separate but equal was not okay. However, if his case would have had a lasting effect, we would have simply stopped the question at Plessy v. Ferguson. We would have stopped the question saying that interracial marriages are not okay. We would have stopped the question that bias on race was okay. The fact that we don't have lasting effects from his case is the reason why things in society are allowed to change, and the Supreme Court is allowed to change its mind, as well as the society as a whole. The case is no longer relevant because the case was a 6-0 decision. Even back then, it was very clear what the decision was going to be. Everyone knew that the United States federal government was going to overcome the state of New York in a case about commerce. This isn't a debatable issue. It was very clear what the answer was. You're going to vote on something that has a lot more controversy surrounding it, like my case, which was overturned in 2008. Next on Foreman v. Georgia. First, I'd like to quote Edward. Edward says that cases about whether or not you can have the death penalty are split into 2 different eras. Pre-Foreman, post-Foreman. If there is anything to split, that means that there isn't a lasting effect. That means that there have been tons of cases up until then, and tons of cases that come after. We've seen this because the death penalty was actually overturned in 1976. His case was in 1972. So within just 4 years, his case lost all effect. Since 2000, 1,200 people have been put up and actually condemned and put to death under the death penalty. So clearly we're not saving a lot of people right now. And in 2011, there are still 3,251 people who have been condemned under the death penalty and are now awaiting execution. Clearly, his case hasn't actually worked to save very many people, if there are still that many people put up to death. So you can see that you're going to vote on what's relevant as well. His issue is not as relevant to today as a lot of the social impacts that are going to affect all of us, and especially are coming up in the 2011 elections. We need to vote on what case can actually bring democracy into the Supreme Court. Like I said in previous speeches, we've had a lot of problems with changing how we vote for the president, changing how we vote for the Senate, so that we can have more democracy. My case is what ensures that we bring democracy into the courts. It ensures that the courts have to look at what we as citizens view to be the most important and pressing issues. We shouldn't allow them to just make decisions based on 18th century America, because things have changed within the past 200 years. We want them to decide what best represents us. And this case has set the precedent and for the Supreme Court to take a step back on these controversial issues and actually look at what the people want to be decided. It is because of my case that we could have the overturning of Plessy v. Ferguson, that we can have the Supreme Court change their minds, because what society views as appropriate changes as the time goes on. My case sets the precedent for the Supreme Court to take these things into consideration. And that's why my case will be the most important, because it has had a lasting effect. It was decided in 1997, and that's why we don't have cases about healthcare, and it is relevant to gay marriage, abortion, and healthcare, all prevalent issues today.